Next case is Gentry Transportation versus 4 Points. Good morning.
Good morning, Your Honor.
If you want to reserve some time, let me know, and I assume the clock on the podium is working to assist you in keeping your time. So with that, we'll go ahead and
reserve 5.
Okay.
I please the court. I'm Tom Band. I represent Gentry Transportation Services. We're here on appeal for attorney fees on 2 different statutes. As you see in the facts, this was a small claim matter for $2,600. My client filed it himself. He had to hire me when a counterclaim was filed for $4 million. And through the course of this discovery of the manager of the LLC, 4 Points, the $4 million was computed as $100,000 a year for the next 40 years for a contract that's terminable at will, a contract that doesn't require any specific sales transactions or transactions at all between his customer and 4 Points. There was no basis for $4 million. They filed the suit. We put them on notice under 57-105, gave them a 21-day safe harbor provision. They ignored that. And this court has ruled that it's mandated that safe harbor provision, if you exceed that, you're going to be hit with attorney fees. And that's what should have happened in this case.
Explain to me the nature of the dismissals that occurred in this case, because as I understand it, there appears to be a dispute about whether certain claims were voluntarily dismissed or involuntarily dismissed.
Yes, Your Honor. We had first of all, when the Mr. Sturmer, the original counsel, was substituted, got out of the case, and Mr. Schroth took over. Mr. Schroth filed a notice of voluntary dismissal of the counterclaim, as well as a motion to dismiss the entire case with prejudice. But this was after we already had a hearing on a motion for summary judgment in which the court reserved ruling.
And ultimately decided he shouldn't have reserved ruling, he should have just denied it because it was mooted by the fact that the other side wanted to file an amendment, correct?
Correct, which again is wrong because the American title case that I cite says when you're faced with a summary judgment motion, the court can't permit it to be defeated by the defendant, or in this case the counterclaimant, coming up with another theory to defeat the summary judgment. In other words, the motion for summary judgment was addressed to the pleadings that were already in the court file, and it should have been granted. Leave to amend could have been granted still after that, but for the issues brought, and if you read the transcript of the judge, he found out there was no way they could bring that action. The documents in support of the
Couldn't the trial court grant leave to amend and in the course thereof, therefore, moot out the motion for summary judgment?
I don't believe it was mooted, Judge, because of the fact that the motion for summary judgment was directed to the pleadings that were in the court file at the time.
And he allowed them leave to amend those pleadings, correct?
They actually filed a motion, amended pleading with their motion.
So why doesn't that moot out the motion for summary judgment directed to the unamended pleading? The unamended pleading is not before the court anymore. How can you rule on a summary judgment on that anymore?
It was before the court. It was before the court because the amended pleading is not before the court until you get leave to do it. The original pleading is before the court at the time we filed the motion for summary judgment, at the time we filed the notice of hearing, at the time we had the hearing. It was there, it was before the court. If someone wants to add additional counts, let's say if they weren't going to try to still claim a breach of contract, which the court said they couldn't. But let's say they had some other theory for some other thing unrelated, and they had the parties in there, they could amend and they can come in and bring in some other theory that doesn't affect the theory that they brought originally. On that theory, on those issues, in summary judgment or decide issues, there's no issue of fact. As a matter of law, we're entitled to summary judgment.
Well, the bottom line is the trial court found that it was a voluntary dismissal without prejudice. Isn't that correct? I mean, that's the ultimate conclusion that the trial court reached.
No, the trial court ended up dismissing it with prejudice, involuntarily. That was his order. It was an order of involuntary dismissal with prejudice. This trial court he does his own orders. And no one submitted an order to him. He does prepares his own orders. after we had the hearing, he prepared this order, and he changed it to an involuntary dismissal of the whole case. So involuntary dismissal of the whole case is an adjudication on the merits under the rule. Therefore, Gentry is the prevailing party.
Didn't he acknowledge first the notice of voluntary dismissal of the counterclaim, and then proceed to dismiss the remainder of the case involuntarily?
He just recognized that they filed it. And as pointed out in
The trial court specifically recognized that 4 Points voluntarily dismissed its counterclaim without prejudice, didn't it?
he recognized that.
Okay,
yes.
and that's the crux of the room, because if that's the case, then you're not entitled to the fees. There's no entitlement to fees on the.
We're still entitled to fees, Judge, because it's a nullity, because we already had the hearing on the motion for summary judgment, and we already had prejudice to my client, because they were trying to do it to defeat the fees.
Doesn't the dismissal have to be with prejudice under the holdings of numerous cases from the Supreme Court down the opinions issued from this court?
Well, it has to be
And if the
equivalent.
trial court recognized that it was a voluntary dismissal without prejudice, it vitiates the right to fees, doesn't it?
No, Judge, because it was filed at the wrong time. It was filed after the hearing on the motion for summary judgment. Under the rule, you have to file your dismissal, voluntary dismissal, before there's a hearing on a motion for summary judgment, and so long as it doesn't prejudice the other party.
If the trial judge had denied the motion for summary judgment, could they have voluntarily dismissed their counterclaim?
If he would have denied at the first hearing,
Yes. You have a right to voluntarily dismiss after a motion for summary judgment has been filed if it's denied, correct?
correct.
The mere fact that you've held a hearing on it doesn't take away your right to voluntarily dismiss it, correct?
Correct.
It's only if the summary judgment is pending or granted, correct?
Correct. And even if it would have been denied and they would have done that, the courts on its own involuntarily dismissed it by entering the order he did enter. He didn't have to enter an order of involuntary dismissal. That's what he called it. He could have just called it order on the motions. He could have called it order ratifying the voluntary dismissal.
And he did that because he recognized that there was a voluntary dismissal without prejudice to give an opportunity for an amendment. The amendment never produced itself, and that was the basis for the trial court to then proceed to dismiss it. Isn't that correct?
But it was the fashion the judge did it, Judge, by making an involuntary dismissal, the last order he entered, he adjudicated the merits of that, and that made it with prejudice. They cannot bring that counterclaim back. That made it with prejudice.
I'm concerned about your argument that somehow the court can't give a party leave to amend and therefore moot out the summary judgment. If I filed a complaint against you and I said something happened 5 years ago and you moved for summary judgment on the statute of limitations because it was a 4-year statute of limitations, and I came back and said I want to move to amend because I want to allege that I couldn't reasonably have found out about it until 2 years ago, for example, so the statute doesn't apply. Is it your position that that doesn't keep you from going ahead and you're entitled to a ruling on your summary judgment that the statute of limitations has passed because the pleading that was there before I asked to amend said it was 5 years ago?
If it's the statute of limitations, I think the judge could still rule on it. Why would he give them leave to amend if 5 years is up? Unless they have another claim.
Because they have,
7 years.
because their argument is that I have some additional amendments to make that will show that the statute of limitations is not a bar.
Well, they raised it when before they came to the hearing, Judge. That would have been raised at the hearing, or before the hearing, in response to the motion.
So if the court grants a motion for leave to amend, he still has to rule on the summary judgment on the original complaint? Is that your argument?
He has to rule on the issues that were brought in a summary judgment.
Even if he grants leave to amend before he hears the summary judgment motion? That makes no sense to me.
Well, he heard the summary judgment motion.
And he said, ultimately he said it was mooted by the fact that I gave him leave to amend, correct?
But but he still entered an order saying he reserved it. In other words, reserved means it could still be granted, could still be denied, but they didn't do anything. Since they didn't do anything, it should have been granted. That's our position. The facts that they brought in, they had no contract, enforceable contract, they had no damages, and he said over and over again, even the amended counterclaim they attached to their motion it'd be stricken. So if you strike a counterclaim, is that not granting the summary judgment? The other issue we have, of course, is the 57105. 57105 was amended in 99 and then again in 2002, where Section 4 was added. It gives you the 21-day safe harbor to be more in line with Rule 11 of the federal rules. We gave the defendant as counsel, or I should say counterclaimant as counsel, the notice, proper notice under the rule. They continued to litigate the matter, continued to litigate it. This court held in Delta Fire Sprinkler that once you continue to litigate beyond the 21 days, you lose your immunity from getting hit with attorney fees, and you owe attorney fees. And the other cases I cite say the same thing.
Were there issues in this case as to whether or not your client had timely delivered the goods and whether or not there were any damages as a result of a failure to timely deliver the goods?
They were trying to raise the damage to their customer, but not a damage to them, other than they're saying their customer didn't pay them. But they never brought their customer in. They never sued their customer.
Was there an issue as to whether the customer was even lost, whether there was a continuing business relationship?
They still had a continuing business relationship.
Was that was that an issue that was supposed to be decided, an issue of some merit, or was that?
No, what I'm saying is they alleged they were damaged because they lost this customer. They estimate this is the only time one shipment they ever had from them for $2,600, what we charged, and they charged their customer like $3,400. They were going to get $100,000 in profits from this customer for over the next 40 years.
But they also alleged that they were damaged because they weren't paid for them fully because they weren't timely delivered, correct?
Right, but again, they never went after that customer.
Well, why would they have to? If your client didn't timely deliver them, maybe they don't think their customer did anything wrong by not paying them because it wasn't time. Why would they have to go after their customer as opposed to refusing to pay your client because you didn't timely deliver?
Their customer is supposed to come after my client. My client was a broker. Four Points is also another broker. We hired trucking companies to move the freight. The Associated Growers was the shipper in this particular transaction. If they had damage, they're the ones supposed to bring the claim, not 4 Points Logistics. So they didn't have any standing to make that claim. And but the lower court was following the old law, and it was stressed to him by counsel to follow the old law under 57105, and they totally ignored the safe harbor provision. And the statute provides that, and the courts have held that it mandates imposition of attorney fees once the attorney and the client proceed beyond the 21 days. And that's what happened here. For almost a whole year went by, and they continued to litigate. So fees are warranted. The Smith versus Gore case I cite from the first DCA says that the shall assess attorney fees. Delta Fire Sprinklers case decided by this court last year makes it mandatory to impose attorney fees beyond the safe harbor. Mullins, which the court relied upon, that was decided before the 1999 amendment to the statute. And so for the court to just look at the time they filed, they may have had some kind of claim that was good enough, and therefore there's no sanctions warranted under 57105 is completely wrong according to the statute, according to the case law. The attorney and his client knew or should have known, especially when they sat down. They had to sit down and come up with $4 million before they filed suit. They didn't simply just allege that it exceeded $15,000 to get in circuit court. They alleged damages of $4 million. And there was no basis for that in law or fact. And when we filed our motion, they should have dropped it. They kept going. 57-105-4 says that states that the paper has to be withdrawn or appropriately corrected, and that wasn't done. They did not withdraw it.
I'm coming up on 5 minutes. You wanted to reserve that.
All right, thank you, Your Honor.
Going if you want, or you can stop and reserve it. It's up to you.
I believe I've mentioned all the cases I can mention. And so I will just reserve the 5 minutes.
Okay.
Thank you.
And please, the court.
Here, let me get the clock properly set here.
Yes, Your Honor.
Wait a minute. Okay, go ahead.
Your Honors, my name is Derek Schroff. I'm with the firm of Bowen, Ratz, and Schroff. I represent the appellee in this case, 4 Points Logistics, LLC. And first, I'd like to address the 57-105 motion that was filed. That particular motion was filed October 12, 2005. On October 12 of 2005, after that motion was filed, the deposition of Harold Bibby was taken. As noted in Appendix B to the appellant's brief, that deposition, page 68 in particular, Mr. Bibby specifically outlines how he came up with his figure for damages, calculating potential lost profits at $100,000 a year for 40 years. There is, as Your Honor noted, also a claim for the damages sustained as a result of the failure to timely deliver the flowers. So in addition to the actual core damages claim, there was a claim for special damages pled in the counterclaim. The trial court...
Was there testimony that the customer was actually lost or not lost?
The testimony from the deposition was not clear either way. I don't think that came up. There was an affidavit submitted at the final hearing where that affidavit indicated that, and it's part of the record, I can cite the transcript later, that Mr. Bibby indeed lost that customer because of this delivery. It's also important to note that this particular delivery was part of a promotion, and I have a specific citation for the court, where Mr. Bibby, quote, says it was a very important run, unquote, and this is page 18 of his deposition appendix B, and he says, quote, it was a promotional product that was due for the holiday weekend for Thanksgiving week, and everything was pretty much writing on it. It's page 18. They had entered into a contract. They anticipated a long business relationship together. That did not happen because the flowers were not delivered timely. The issue as to whether there was merit or facts supporting the claim, the trial court found that there was. As this court is well aware of, the standard is an abuse of discretion standard.
Isn't the real hard issue, though, whether or not it was involuntarily or voluntarily dismissed? Because if it was voluntarily dismissed, we don't have to get to the merits of the 57-105?
Correct, Your Honor. And on that issue, the voluntary dismissal with prejudice, which for the record is 226, clearly indicates that it was, quote, voluntary, unquote, and without prejudice also, quoting from the dismissal. The court, in addition to paragraph 4, notes in paragraph 1 that counterclaim, quote, was properly dismissed, unquote. So the judge recognized it in accordance with the Ormond Beach holding of this court in 2002, where the court in that case also recognized the notice of voluntary dismissal without prejudice, and there's a long line of cases which says that is not an adjudication on merits. So as far as the argument that summary judgment, that the notice of voluntary dismissal without prejudice was not timely filed, in this case, the judge, number one, he later denied it, as you know, but that was a voluntary dismissal. It was not an adjudication with prejudice. The court's order also does not indicate with prejudice. So with 57-105, I would just like to quote the court in applying the correct standard. I argue that hearing and at the court, and for the record, before the summary judgment, before the attorney fee motion was argued, I specifically disclosed to the court, and this is the second transcript, page 13, that the statute had, quote, changed, unquote, and I even specifically cited that not only when it was initially presented as the standard, but also, quote, or at any time before trial, unquote, and that's page 13 of the transcript. The court, even though in its order it found that there was a claim when initially presented, that order, if you look at the preface, incorporates the court's reasoning at the hearing. And at the hearing, the court specifically said, and this is second transcript, page 27, the claim itself was, quote, a cognizable claim. The facts, quote, certainly gave rise to at least a claim, unquote. And then the court applies the correct standard. The test is whether or not there was a claim that asserted a fact that was frivolous, and in this case, there's certainly still an issue, even today, as to some of those facts. So even after the dismissal occurred, the court said, even today, we're arguing about those issues of fact. Thus, the claim had merit, as the court found. On the issue of the offer of judgment, the court reserved ruling and held that it was, quote, moot, also, quote, stale, because he had granted the motion to amend. Rule 1.190 specifically allows a party to amend and a judge to freely give amendments. So the motion for summary judgment hearing actually didn't happen. After the court made that ruling, plaintiff's counsel then argued the summary judgment. At the end, the court concluded by saying, well, it's a moot issue. I'm going to reserve ruling. I don't know if that meant reserve ruling to have another hearing or reserve ruling on the actual merits of the hearing. But later the court ended up dismissing it, denying that motion for summary judgment, saying he had made a mistake before. How could he reserve ruling on a motion when that motion is made moot by a potential amendment? Because that motion for summary judgment was directed at a counterclaim which no longer exists because they was given leave to amend. And the trial court specifically says in the second transcript, page 12, I may have signed an order that said I reserved ruling, but in truth that would have been erroneous. If in fact it says that, because if they amend, if an amended pleading is filed, a motion directed to it would have to be refiled. So I couldn't reserve jurisdiction on. I mean, that would have been an erroneous act on my part, and I acknowledge that. So it had to be in effect a denial of the summary judgment with leave to amend the counterclaim. So under 1.420A, if the motion for summary judgment is denied, as Your Honor noted, we're free to dismiss the claim. But suppose if plaintiff's argument, appellant's argument on appeal is that there was a summary judgment hearing, the court reserved ruling, thus it was still pending, it wasn't dismissed at the time we filed, essentially what does that do to our notice of voluntary dismissal without prejudice? Well, what it does is it makes it a nullity under Glennis versus Forrest, River 931-7-2nd, 4TC, a case 2006. Well, that case said, and that was clearly where a hearing had been had and wasn't subsequently denied, and the motion or the notice of voluntary dismissal without prejudice was filed. The court said, well, it's a nullity. Well, where does that leave us? If you remand and say it was a nullity, we would prosecute our counterclaim or just simply file another notice of voluntary dismissal without prejudice. That's where it would leave us. So first of all, there wasn't a hearing, so the dismissal is appropriate. If the court determines there was a hearing, it was later, that motion was later denied. So under 1.420, we're free to file our notice of voluntary dismissal without prejudice. So we respectfully request that the court affirm the trial court's ruling below and end this litigation between the parties. Thank you.
Okay. Five minutes.
Thank you. The voluntary dismissal has nothing to do with 57-105, unless it was filed within that 21-day rule.
But it has to do with specifically, the trial judge specifically ruled in the order that was the basis for denial of fees under the offer of judgment statute. And the trial court specifically found in his order that the motion for summary judgment is denied because the motion is moot. And then it recognized the counterclaim was dismissed without prejudice. And he says that's the basis for the ruling of the offer of for denial of fees under the offer of judgment statute.
Offer of judgment.
And so I'm having a difficult time with your argument that we should say that all of those findings by the trial court and that ruling by the trial court is erroneous when the trial court specifically said what it did with the motion for summary judgment and with the dismissal and how it considered the dismissal.
But again, it's because he's stating that under the offer of judgment attorney fee statute, he's saying that he's changing his ruling from the previous ruling on the summary judgment.
Well, he's explaining what happened, I think, is what he's doing. And he's specifically saying that the summary judgment is denied because, and I'm quoting from the order, is because the motion is moot. And the counterclaim to which it was directed was properly dismissed. And then he goes on to say it was dismissed without prejudice. And that's the basis for his ruling for denying attorney's fees under the offer of judgment statute. And I'm having a difficult time finding that that's an incorrect ruling. You need to help me with your last remaining minutes.
Yeah, well, I came up here to address what Judge Palmer talked about, the voluntary dismissal. Voluntary dismissal has nothing to do with 57-105.
I know that. Well, as far as the trial court's order is concerned, he said that 57-105 fees were denied because there were merits in the issues. There were some merits in the issues.
Right. And this is after he said in the hearing that the $4 million claim was an exaggeration. The contract, there was no enforceable contract. There were no enforceable damages. Even if the proposed amended counterclaim would have been stricken. So there was no merits. He found no merits at the March 29th hearing in any of the counterclaims proposed or brought by the.
But in the order, the trial judge specifically says fees under 57-105 were denied because the defendants initially presented a claim which was supported by the material facts necessary to establish the claim, supported by the application of existing law to those material facts. And so that goes to the issues about, number one, whether, there was timely delivery and all those other issues that we talked about before, right?
No, it has nothing to do with the counterclaim.
Okay.
That would have to do with not paying the $2,600, not bringing a $4 million
Well, the
counterclaim.
counterclaim had to do with the fact that, that they suffered damages because the client was lost, because there was late delivery. And so that goes to the issue of, well, was the client actually lost, and, were the flowers delivered late?
The 4 points concedes on this appeal the fact that they cannot get those damages. They cannot get those damages under the law.
Can 4 points bring a new claim on the counterclaim for any damages at all arising out of this transaction?
The $2,600 is the only transaction they had. That's been done and paid for, finally, after this lawsuit. The other thing they have is something that, as I say in my brief, and they concede it, you have to have notice of these special damages or these consequential damages before you can be liable for it. There was no notice, so there's no liability.
Was the counterclaim dismissed with prejudice or without prejudice?
It's still our position it was dismissed with prejudice by that order of involuntary dismissal which the court entered. The court did not have to enter an involuntary order of dismissal. Our claim was paid for by the defendant after Mr. Stroth got in the case, and the only thing that had to be done there was it was over, satisfied basically. Involuntary dismissal of the entire case. That's what they asked for, the entire case being involuntary dismissal, and that's what the court granted. Regardless of the wording of the other words in the order, he still entered an order of involuntary dismissal. And it's our position that's with prejudice, and they cannot bring the claim. And again, the claim was frivolous from start to finish because of the fact of all the arguments I made in my brief about they had no standing, we had no notice of any special arrangement that they had with their customer, who put us on notice of these damages that they claimed. So
Okay,
the entire...
Your time's exhausted. All right. Thank you very much.
Thank you.
Well argued on both sides. We're going to take a break. We'll have a change of